Jury nullification is the last line of defense and can turn around even the worst situation. In 1843, a man named Jerry escaped slavery in Missouri and made his way to New York. His birth name was William Henry, and he was 40 years old. He lived free in Syracuse for 8 years before he was arrested in 1851 under the Federal Fugitive Slave Act. Syracuse was an abolitionist hotspot, the great central depot of the Underground Railroad. Earlier that year, the hated Secretary of State Daniel Webster had warned that the law would be enforced even here in Syracuse, in the midst of the next anti-slavery convention. Jerry's arrest was considered a message from the federal government that it would aggressively enforce the locally unpopular law. But the people there were not intimidated by Webster's federal threat, and Jerry had a lot of local support. An immediate effort to free Jerry helped him escape to the street in irons, but he was quickly recaptured. He was then relocated to a more secure room, but a crowd of 2,500 people surrounded the building, and reports said they overwhelmed them by numbers, not by blows. Jerry was brought to a safe house, and a few days later he made his way to freedom in Canada. The federal government put 26 people on trial for helping him escape, but only one person was convicted. That's because they couldn't seat a jury in the area willing to do anything but acquit. Turning the tables, the rescuers actually got a state law indictment against Marshall Allen for kidnapping Jerry, and used the occasion to argue against the constitutionality of the fugitive slave law. While Allen wasn't sent to prison either, the entire episode shows how people used various tools to block the practical effect of the pro-slavery federal act in Syracuse. Next, we'll talk about how to put all these different ideas into a big picture strategy. Nullification is most effective when approached with a combination of strategies. As we learned from both Patrick Henry and John Dickinson, resolutions affirming specific principles can be an important starting point. And as we discussed in more detail last season, this was the same approach Thomas Jefferson and James Madison took with the Kentucky and Virginia resolutions of 1798. They were intended as a first step. Whatever the first step may be, a winning strategy needs more than one step. It requires approaching the issue from various directions. We've seen this employed effectively against everything from the Stamp Act in 1765 to alcohol and marijuana prohibition in modern times. From this experience, we can use 4 main principles to build an effective strategy against federal programs today. 1. Education. Non-binding resolutions bring the issue to the forefront of the public discussion and can set a principled foundation for further action. John Dickinson called on colonial assemblies to do this in support of New York against the Townshend Acts. The Stamp Act Congress took the same approach. Patrick Henry's Virginia Resolves did the same, but also included a strong call to action by the people. And the resolutions of 1798 were considered a starting point by Thomas Jefferson and James Madison. 2. Individual action and resistance. As we've learned from the Real ID Act of 2005, even the strongest resolutions and state laws don't stand much of a chance if the general public simply complies with a federal act. However, official actions from state or local governments can move widespread individual resistance into the winning column. 3. Official noncompliance. While not widespread, a refusal to enforce the Stamp Act by various government agents helped bolster efforts already happening in the general public. The same thing has happened in modern times, with cities and states standing down on both alcohol and marijuana prohibition, creating a climate where a full federal repeal becomes inevitable. 4. Jury nullification. Arrest sometimes goes hand in hand with resistance. A full-spectrum nullification strategy accepts this, deals with it, and uses jury nullification to minimize the harm done. fully informed juries are the last line of defense and can set people free even after arrest. In recent years, more than 24 states have passed non-binding resolutions rejecting federal overreach. In most situations, it's time to move forward to more direct action. As we covered last season, Thomas Jefferson advised pushing as far as events will render prudent. Next, stay tuned for part 2 of this series, where we'll share with you just how to put this strategy into practice today. Efforts to protect privacy at the state and local level have a significant spillover effect on federal surveillance programs. Much of the funding for surveillance programs at the state and local level comes from the federal government. In return, federal agencies tap into the information gathered by state and local law enforcement through fusion centers and a federal program known as the Information Sharing Environment. The ISE serves as a conduit for the sharing of information gathered without a warrant. The federal government encourages and funds a huge surveillance network at the state and local level, thereby gaining access to a massive data pool on people without the manpower needed to collect the information itself. In a nutshell, if states don't share or even collect that data in the first place, the feds will have a far more difficult time conducting the mass surveillance that they want to. This can represent a major blow to the surveillance state and a win for privacy. There are currently 3 main areas where states can pass legislation to protect privacy locally and help thwart some federal surveillance programs at the same time. We'll talk about those next. It's not just the NSA that's spying on you, and state action can help end it. There are 3 main areas where states and even local communities can pass legislation to protect privacy locally. This also helps thwart some federal surveillance programs at the same time. 1. Stingrays or cell site simulators. These portable devices essentially spoof cell phone towers, tricking any device within range into connecting to the simulator instead of the tower, allowing law enforcement to sweep up metadata, location information, and even full content from phones within range of that tower. The federal government funds the vast majority of state and local purchases, and they often require non-disclosure agreements. This throws a giant shroud of secrecy over the program, even preventing judges, prosecutors, and defense attorneys from getting information about the use of these devices. The feds actually instruct prosecutors to withdraw evidence if judges or legislators press for information. Since 2015, 4 states, Washington, California, Illinois, and Louisiana, have new laws limiting the use of stingray devices, requiring a good old-fashioned warrant in most situations. 2. Automated license plate readers, or ALPRs. As reported in the Wall Street Journal, the federal government via the Drug Enforcement Agency tracks the location of millions of vehicles through data provided by ALPRs operated on a state and local level. They've engaged in this for more than 8 years, all without a warrant or even public notice of the policy. Police generally use ALPRs to store the photograph, the license plate number, and the date, time, and location of a vehicle's license plate, which is bad enough. But according to recently disclosed records, these systems also capture photographs of drivers and their passengers. With the FBI rolling out a nationwide facial recognition program and aggressively building a giant biometric database with pictures provided by the states, the feds can potentially access stored photos of drivers and passengers, along with detailed data revealing their location and activities. With this kind of information, authorities can easily locate and track individuals without warrants or oversight for any reason whatsoever. Since most federal license plate tracking data comes from state and local law enforcement, laws banning or even restricting ALPR use are essential. In 2015, Minnesota became the 4th state to place restrictions on the use of ALPRs, joining New Hampshire, Utah, and Arkansas. As more states pass such laws, the end result becomes more clear. No data equals no federal license plate tracking program. 3. Drones, also known as UAVs. UAVs can be equipped with all kinds of surveillance technology, including cameras, stingrays, and even facial recognition. Many local law enforcement agencies only get them with federal grant money. One drone manufacturer advertises on its website that police departments wanting to own a drone should seek funding from the Department of Homeland Security. Another recommends getting the money from FEMA. Since 2013, 12 states have taken initial steps to require a warrant before surveillance is done by a drone and to prevent sharing of any data collected. While state laws in these three areas focus exclusively on limiting state and local spying, by significantly reducing the amount of data collected and restricting or ending any sharing of that data with the feds, they throw a high hurdle in front of some federal surveillance programs. This is a strategic move that helps protect privacy, even as the federal government is totally unwilling to follow the Fourth Amendment. But states can even go head-to-head with the NSA, and we'll talk about that next. States can go head-to-head with the NSA by exploiting a serious Achilles heel. In 2006, reports surfaced indicating that the NSA had maxed out capacity of the Baltimore area power grid. Insiders said, the NSA is already unable to install some costly and sophisticated new equipment. At minimum, the problem could produce disruptions leading to outages and power surges. At worst, it could force a virtual shutdown of the agency. In other words, the NSA has an Achilles heel. To get around its power problem, the agency started searching for additional locations. Due to cheap utilities, primarily water, the NSA built a massive facility in Bluffdale, Utah. The water-cooled supercomputers there require millions of gallons of water every month to stay cool and functional. That water is provided by a political subdivision of the state of Utah, but they don't have to do it. As advised by James Madison in Federalist No. 46 and supported by the Supreme Court in the Anti-Commandeering Doctrine, the states, including their political subdivisions, are not required to provide manpower or resources to help implement federal programs. In other words, Utah can turn that water off. No water equals no NSA data center. But it's not just Utah. The agency built the Texas Cryptologic Center in San Antonio primarily due to the state's independent power grid. The electricity there is provided exclusively by a city-owned power company. The Threat Operations Center in Augusta, Georgia, has its water and even sewage treatment provided by local government services. NSA also has facilities in Colorado, Washington State, West Virginia, Tennessee, and Hawaii. A state-level Fourth Amendment Protection Act prohibits a state and its political subdivisions from providing material support or resources to NSA facilities. This could apply to anything from water or electricity to traffic control, snow removal, and even sewage treatment. In states with NSA facilities, the act could either ban renewal of existing contracts or in some cases even void current ones. In states without facilities, the legislation might be even more important. With increasing resource requirements, the NSA will certainly continue expanding to new locations. Banning material support or resources right now would prohibit new facilities from ever getting out of the planning stage. The question most people ask, of course, is this: can it actually work? Well, it already has, and we'll share that story next. Can states legally and successfully shut off water to a federal agency? Absolutely. It's already been done. Yucca Mountain is in Nevada, about 90 miles northwest of Las Vegas. It was originally selected as a nuclear waste dump in 1987, but it wasn't until 2002 that President Bush and Congress officially approved the site and moved to make the dump a reality. This was not a popular move in Nevada. The governor filed an official notice of disapproval of the site selection, but the federal government rejected it. Nevada filed several lawsuits disputing the EPA's standards for the site and asserting the Nuclear Regulatory Commission's duty to uphold public health and safety standards. To run the drill rigs necessary to take soil samples, as well as other operations, the feds needed to pump more than 140 million gallons of water to the area each year. But state law governs the use of groundwater, not federal law. In 2002, the U.S. Department of Energy filed applications for permanent water permits with the Nevada Division of Water Resources. But the state engineer rejected the applications on the basis it was detrimental to the public interest and that the state legislature had previously determined it was unlawful to store waste at Yucca Mountain. Nevada still allowed federal officials to use a limited amount of water at the site for showers, restrooms, and fire emergencies. Eventually, the DOE began ignoring the restrictions and started drilling operations anyway. In the summer of 2007, state engineer Tracy Taylor issued a cease and desist order blocking further water use for drilling. The feds filed an emergency injunction challenging the order based on the supremacy clause of the Constitution. The DOE motion asserted that the state wasn't just protecting its water rights, but trying to block a federal project. Surprisingly, the federal court sided with Nevada. In his 2007 opinion, the U.S. District Judge wrote, "The validity of Western states' groundwater rights and the right to regulate water in the public interest is not a right to be taken lightly, nor is it a right that can cavalierly be ignored or violated by a federal agency." Regarding the Supremacy Clause argument, he wrote, "At present, the only public interest issue is whether state officials can be precluded from exercising their lawfully mandated duties or whether a federal agency can run roughshod over a state's rights or interest without specific authority and mandate to do the precise activities it wishes to do." The department appealed the decision, but due to the long-standing roadblocks, the feds announced plans to kill the project in 2010. As a result, the DOE withdrew its water application, effectively ending the lawsuit. While there have been efforts to revive the project, today it remains effectively dead. Even if Congress does resume efforts to build, the feds will still have to find a way to get water. Refusing to provide water to a federal agency worked. The feds didn't just march up the mountain and take the water, and trucking it in was both cost prohibitive and almost logistically impossible. Even a federal court upheld the right to refuse cooperation under the anti-commandeering doctrine, and the state action ultimately forced the federal government to scrap its plan. "70 years of federal gun control is not going to be overturned by Congress or the courts, but step-by-step actions by states can help bring it to an end." Without state cooperation, the practical effect of most federal programs becomes severely limited. This is exactly what James Madison advised in Federalist No. 46. This is also why Judge Andrew Napolitano recently said that a single state refusing to assist in the enforcement of federal gun laws or regulations would make them nearly impossible to enforce in that state. Nullifying federal gun control can be approached in 3 very straightforward steps. 1. Draw a line in the sand. Legislation to ban state and local enforcement of any and all future federal gun control measures is the first step to start the healing. Passage in multiple states would ensure that any new federal gun control measure would never really get off the ground. Additionally, it helps educate the public on the legal and constitutional foundation for the state to take such action, or stronger ones in the future. 2. Fortify and build. This next step bans state and local enforcement of specific current federal gun control measures. For example, a bill to remove any state-level prohibitions on firearms that fall under the federal gun control measures enacted in 1934 or 1968. Or has been done in 24 states on marijuana, a state could simply legalize or decriminalize firearms that the federal government prohibits. This removes a layer of prohibition and minimizes enforcement efforts, encouraging people to simply ignore remaining federal regulations over time. 3. Add local support. Counties, cities, and towns should take the same approach, and a number around the country already have. For example, in May 2013, the City Council of Herndon, Kansas, passed Ordinance Number 510. It prohibits any agency or person employed by the city from enforcing, providing material support for, or participating in any way in the enforcement of any act, law, treaty, order, rule, or regulation of the federal government regarding personal firearms, firearm accessories, or ammunition. Strategically thinking, in some states, starting at the local level is the best first step. Blanketing a state with ordinances or even resolutions in support of measures can build a groundswell of support to do the same on the state level. Next, we'll examine inactive firearms freedom laws in 9 states and steps that can be taken to put them into effect. Nine states have firearms freedom acts on the books, but not one has put it into effect. First signed into law in Montana in 2009, then Tennessee, Firearms Freedom Acts declare that firearms manufactured in the state and remaining in the state are exempt from federal firearms regulations under the Commerce Clause of the Constitution. Unfortunately, however, not one of these states have taken action to effectuate these laws. They've all seemingly decided to wait on federal courts to give them permission to do so. As you might have guessed, this isn't going too well. A lawsuit in support of the Montana law was first thrown out in U.S. District Court for lack of subject matter jurisdiction and failure to state a claim. On appeal, the U.S. Court of Appeals for the Ninth Circuit overturned the District Court's determination on lack of standing, but also stated that existing Supreme Court precedent does not favor the legislation. The Supremes ultimately refused to hear the case. The 2005 Gonzalez v. Raich case addressed the issue of medical marijuana on a state level. Even though the plaintiffs lost the case, they provide a blueprint for Firearms Freedom Act states to follow. After the case, no state repealed their medical marijuana laws, and the number of states with them has more than doubled since. So what should happen next in states with Firearms Freedom Acts? Similar to states with marijuana dispensary laws like California, Oregon, and Hawaii, they should pass laws expressly permitting individuals or businesses to engage in the manufacture and sale of firearms that fall under the Firearms Freedom Act. These state-based firearms manufacturers would be approved, permitted, or licensed specifically under state law, but still be considered illegal under federal law. Ultimately, the success of these acts will rely on the willingness of the people to put them into practice. But as more than 24 states have shown already, such moves by a state can be enough to get the ball rolling. Next, we'll shift gears and take a look at how states can take on the Federal Reserve. There are 4 steps states can take to protect themselves from the Federal Reserve and restore sound money. We'll cover the first 2 next. The Constitution is not merely a set of suggestions, so when it says in Article 1, Section 10, "No state shall make anything but gold and silver coin a tender and payment of debts," it means exactly that. Recognizing that the departure from gold and silver backing to money has led to crushing debt and great financial instability, some state legislatures have begun to take action. In particular, Utah has charted a path towards a widespread acceptance of gold and silver, declaring any gold and silver coins issued by the U.S. government as legal tender in the state and free from any taxation. Oklahoma followed with a similar law in June 2014. These laws help dispense with the notion that gold and silver are merely investments or speculations. Gains on investments, more times than not, are taxed in one way or another, but reaffirming gold and silver as money removes the tax on their exchange and encourages their use. One thing that's essential for gold and silver to be used more regularly as money is the elimination of regulations that decrease its liquidity, and therefore its usefulness. Many state and local jurisdictions impose draconian rules on dealers who buy gold and silver from the public, reducing options, raising transaction costs, and endangering financial privacy. Some dealers are required to collect all kinds of personal information from sellers, including names, addresses, social security numbers, voter identification cards, and copies of driver's licenses. On top of that, the dealers are forced to upload all this personal information daily into law enforcement databases, along with pictures of the metals purchased. And finally, some jurisdictions bar dealers from reselling the gold and silver to anyone for as long as 7 days, forcing them to tie up large amounts of capital and absorb market risk. These requirements, which don't apply to redeeming paper money, only redeeming gold and silver, should be eliminated. Next, we'll cover 2 more ways that states can take action against the Federal Reserve's destruction of the currency. Encouraging the use of gold and silver as legal tender and removing regulatory burdens are essential first steps for states against the Federal Reserve, but they can take things even further. Perhaps the most high-profile pro-sound money reform in recent years comes out of Texas. In 2015, a law was enacted that calls for the building of a Texas precious metals depository chartered by the state for storage of its own gold as well as individual accounts. With an account there, people would have the ability to engage in transactions using gold and silver electronically. An account holder could make a purchase and pay the seller by transferring precious metals to the seller's account, or it could be converted to dollars and deposited into an account at a Federal Reserve-sanctioned bank. The ability to transact electronically like this would help bring gold and silver into more regular use. In 2016, the Tennessee legislature passed a resolution supporting the creation of a similar depository in that state, and follow-up legislation to put this into practice should be introduced and passed immediately. A final tool that can be used by sound money advocates is the Gold Clause contract. Per Title 31 of the U.S. Code, a gold clause is a provision that gives parties to a contract the option to require payment in gold rather than Federal Reserve notes. Gold clauses are particularly useful when designing long-term contracts as protection against the ongoing devaluation of volatile fiat currency. If more consenting individuals decide among themselves to require payment in gold, it would be hugely beneficial in broadening the use and acceptance of sound money. For these contracts to truly gain a foothold, they must be fully enforceable in state courts, so states should pass strong protections for requiring performance of parties to Gold Clause contracts. Next up, 3 farmers in 2 states take on the status quo. Three farmers and 2 states provide a blueprint for nullification success. In 2013, Vermont legalized hemp, but when Governor Pete Shumlin signed the bill, he emphasized that hemp cultivation was still illegal under federal law. That didn't stop Nataka White. With the DEA blocking seed importation, he found it impossible to legally obtain the seed he needed. So according to a report by Vermont Public Radio, in the spring of 2014, he illegally imported a small package of seeds from France and started a small patch in his 100-square-foot home garden. When asked about the dangers, he said, "We understand the risks and are willing to go forward in pioneering this new industry. Others followed his lead. As of May 2016, 60 acres of hemp is being grown in at least a dozen locations around the state, all defying federal prohibition. Shortly after passage of Amendment 64 in Colorado, Mike Sullivan started growing hemp. In the last 3+ years, he built up a considerable seed stock at Hemp Farm in Johnstown, and he sells that seed to other farmers. But with the DEA supposedly banning hemp seeds, how did he acquire it in the first place? In an interview with Colorado Public Radio, he said, "We got 1 pound of seed from the stork and the other pound of seed from an old farmer out east that said his grandpa and his dad used to grow hemp up until the late 50s, when they finally shut him down and wouldn't let him grow anymore." As it turns out, the stork was Veronica Carpio. She began developing a strain of hemp seeds even before state legalization in order to produce hemp coffee. Once the crop was legalized, Carpio sold some of her seed stock to several buyers, including Sullivan. He combined his 2 strains to create his own seed. With passage of Amendment 64 in 2012 and fear of state prosecution lifted, people like Sullivan have been even more willing to risk federal prosecution. They obtain seed, grow hemp, and sell their product anyway. As of 2015, there were more than 2,000 acres of hemp growing in Colorado, despite federal prohibition. Since the states legalized the crop and people like Nataka, Mike, and Veronica were willing to take risks for freedom, a thriving industry has taken root and continues to grow. The more that market grows, the less likely it becomes the federal government will be able to interfere at all. States and local communities can stop federal programs that militarize local police. Under Section 1033 of the National Defense Authorization Act for fiscal year 1997, along with other programs like the Department of Homeland Security's Homeland Security Grant Program, the federal government equips local police with military-grade weapons and battlefield-ready equipment to the tune of billions of dollars. Through these programs, local police departments get high-caliber rifles, body armor, and mine-resistant armored vehicles, essentially unarmed tanks. Police departments can even get their hands on military helicopters, drones, and other aircraft. The Defense Department has transferred some $4.2 billion worth of equipment to domestic police agencies through the 1033 program alone. On top of that, the Homeland Security Grant Program hands out just under $1 billion for police departments to purchase this kind of equipment every single year. All this can be stopped without relying on the feds to stop themselves. 1. Assert local control. In 2015, New Jersey became the first state to pass a law with this strategy. It bans local law enforcement agencies from obtaining military equipment without first getting approval from their local government. Currently, these military transfers happen directly between the feds and local police, as if they make up part of the same entity. This approach interposes the local government in the process, giving the people of each local community the power to end it, and at the very least, forcing the process into the open. 2. Ban specific equipment. Montana took things a step further when the governor signed HB 330 into law, completely banning the acquisition of certain military equipment. Law enforcement agencies there are prohibited from receiving drones that are armored, weaponized, or both, aircraft that are combat configured or combat coded, grenades or similar explosives and grenade launchers, silencers, and militarized armored vehicles from federal military surplus programs. Law enforcement agencies could still purchase these items, but it's unlikely because they're banned from using federal grant money to do so. This totally blocks the massive Homeland Security Grant Program. It also creates a level of transparency because law enforcement agencies have to give the public notice within 14 days of request for any such local purchase. By passing this type of measure, states and local communities can nullify the practical effect of federal police militarization programs by simply withdrawing from them. A federal program is undermining some of the toughest restrictions on asset forfeiture, but states can easily put an end to it. Civil asset forfeiture lets law enforcement seize and sell property that they assert has been involved in criminal activity. They essentially charge the property with involvement in a crime, and police can take your money and even sell your car, home, or other valuables without ever charging you with a crime. Over the past few years, there has been a strong movement to reform these asset forfeiture programs at the state level. Most efforts change the standard and require a criminal conviction before police can proceed with forfeiture. This is a great step forward. But all too often, a massive federal loophole exists, and it allows or even encourages state and local police to use the federal government to bypass the state laws. Here's how the federal loophole works. Let's say police pull over a car and find $10,000 in cash. They don't find drugs but suspect it's drug-related, so they take the money. If state law is good on forfeiture, police can't keep the money without an actual conviction. So they will simply claim the case is a federal issue, allowing them to hand it off to a federal agency. This opens the door to a program known as the Federal Equitable Sharing Program, and the police then get to keep as much as 80% of the forfeiture, with only about 20% going to the federal agency. States can easily shut this process down by making sure asset forfeiture reform bills include language expressly prohibiting state and local law enforcement from passing off cases to the federal government to bypass state laws. That forces police to complete forfeiture under the more stringent state law and cuts the feds completely out of the loop. A revolutionary movement. That's how we see nullification today. True revolutionary movements rarely advance under a single, narrow impetus or focus. They are, as Murray Rothbard wrote, made by a mass of people who are willing to rupture the settled habits of a lifetime, including especially the habit of obedience to an existing government. Although revolutionary, the nullification movement of today is not a stereotypical revolution. That is, an uprising characterized by a physical upheaval against the established order. Instead, it's a deeper, more philosophical revolution. It's a revolution in thought. John Adams described the American Revolution against the British in much the same way. In his 1818 letter to Hezekiah Niles, he wrote, "But what do we mean by the American Revolution? Do we mean the American War? The revolution was effected before the war commenced. The revolution was in the minds and hearts of the people, a change in their religious sentiments, of their duties and obligations. This radical change in the principles, opinions, sentiments, and affections of the people was the real American Revolution." Today's nullification movement is revolutionary because it offers the hope of smashing the established political order. It gives us an alternative to voting the bums out, which only results in new bums who violate the Constitution in more costly and dangerous ways each year. And it reminds us that we don't need to rely on the federal government to limit its own power. People have already gotten the ball rolling on each of the nullification strategies we've already shared in this series. Although we limited it to 10 primary issues, you can apply these strategic approaches to just about anything. What's needed, of course, is you. And while it might seem that the actions of one person are small, every step for liberty is actually huge. As the penman of the revolution put it, "Small things grow great by concord."